All right, welcome to Borderlines. It is February 20, 2025. It is just Deanna and I today. And the topic that we are discussing is incomplete applications. This is a topic that has always been of interest to me, and I actually think is one of the most stressful parts of either representing someone in an immigration application or being the applicant. And that is IRCC's policy of returning incomplete applications. And why we decided to do the topic today was that the issue is becoming especially heated in federal court regarding whether the court can even look at decisions that IRCC made to bounce, as they're generally called, an incomplete application. I have, for those on YouTube, some screenshots that I'll be sharing. And for those listening on the audio, we're going to be walking through them. Deanna, I don't know if you have any preliminary thoughts on the topic of incomplete applications. You and I both have a pretty big litigators practice
Mhm.
where R10 isn't really a thing, although the federal court can be finicky. I don't think it's nearly to the same stress-causing extent that those preparing a lot of immigration applications have. I actually said when I think maybe in some of our past episodes with recently retired immigration lawyers that I think that R10, which is the regulation that allows for the bouncing of incomplete applications, fundamentally changed the practice of immigration law.
It sent some great lawyers into early retirement.
Yep.
I think that's true. I think that really to give a picture of what it means, it's kind of like when, like I always imagine, the officer sitting there with yellow highlighters, because I think when our 10 completeness screening first began, it was literally officer sitting there with highlighters. I think that over time, those officers have been replaced with algorithms, but basically, you submit a very carefully, meticulously crafted application, often comprising dozens, if not hundreds, of pages of information and documentation prepared over like with great painstaking efforts and with often quite a lot of fees involved because it's such a laborious process. And then essentially what would happen is that an officer would go through it with a highlighter. And if every single item were not there to the precise description that was there in the checklist, then the whole application would just be returned unprocessed. Now that sounds sort of benign, except that sometimes it would take 9 months, 10 months, 12 months for that completeness process to be undertaken. And by the time that the application came back to you, the rules might have changed such that you no longer qualified in the category in which he would have been applying. So what that means is that a lawyer and their support team or a consultant and their support team is going to prepare the application, have three people in their office check it over. The clients are relying on them. Everybody is heavily invested in a positive outcome, but you miss one check mark. You miss one box. You provide a copy of something that's in color and not in black and white. I mean, there are so many examples we can provide
That's
of.
a specific example because police certificates have to be in color when they're scanned, and there are R10 bounces over police certificates that an applicant uploaded in color.
And sometimes it's like speaking to police clearances. Like if you provide a Korean police certificate, there are two specific words that need to appear in the middle of this, that it's like internal and external search. And if you've had an R10 bounce on a Korean police clearance certificate, you know this. But if you've never
Hmm.
done one before, how do you know what a
Or
good.
if you're representing an Australian, you know that they need a Queensland driver's check and a Victoria traffic report in addition to the Australian police certificate.
The number of things you need to know to look for is astronomical. So we love to talk about, and this was actually the topic of our last and quite, not last, the one before the last, and the probably most controversial podcast we've done in a long time. People like to talk about negligence and misconduct and all of that sort of thing. But the standard of care has kind of reached an impossible height, where the type of mistake that can cause catastrophic and incurable loss to an applicant, the margin of error is so small. And even if you are absolutely up nights worrying about whether or not you ticked the right box or the wrong box and provided the color copy and not the black and white copy. It's almost impossible for humans to not make an error that will cause an R10 bounce. I
I can
think
share
that
my
is,
most ridiculous
yeah,
bounce,
please.
which was towards the start of COVID. It was a family sponsorship application, and the form asked someone to declare for their family members their full address. And this isn't the actual city or the state, but it's the equivalent of the person put in the forms New York, New York. And it took IRCC 9 months to return the application, stating that it was incomplete because the country wasn't listed. And we were able to fix it and everything. But as you note, that's 9 months to return the application over something that seems unbelievably minuscule.
Mm.
The other area that this is starting to really become an issue right now and highlights how these delays in IRCC determining whether an application is complete or not can have dire consequences is if somebody has applied for permanent residence, they are eligible to apply for what is called a bridging open work permit to bridge the gap between when they apply for permanent residence and when their work permit expires and when they get PR. In order to qualify and be eligible for that bridging open work permit, it's not enough that the person have submitted their permanent residence application. It has to have passed R10. What is happening right now is that it is taking IRCC around 2 to 3 months to process these bridging open work permit applications. And in the provincial nominee class, for those not applying through express entry, it is taking around 5 to 6 months to do the R10 assessment. And there have been a flurry of refusals with people thrown out of status because they are waiting for IRCC to do the R10 assessment. And again, we kind of have talked about this before too, how frustrating it is that different aspects or offices within the same department don't talk to each other
Mhm.
because it's not just you've applied to the same department for two separate things, and the office on the fifth floor is not going to wait for the office on the third floor. They are just making refusals.
And in the meantime, I'm sorry, but you can't work right now because you don't
Hmm.
have the authorization you require. In fact, you might need to move back to your country of citizenship while we wait for the third floor and the fifth floor to speak to one another. That's the level of kind of mind-bending reality.
Oh, it's wild.
Yeah, it's
It's
pretty
wild.
wild. It's pretty wild.
As far as what the letters look like, I've just shared it for those listening on YouTube. This is standard form letter. It's not client specific as listed on my blog. Anyone who has gotten an R10 incompleteness letter will have received similar language. This one is for family sponsorship, and they just state, please note that your application has been rejected for the following reason, and it will be rejected as incomplete as soon as one requirement is missing. On another note on that, one of the other frustrating things about the R10 assessment is that as soon as an officer determines that one thing was incomplete, they stop right there. They don't review the rest of the file outside of the parent and grandparent program. They stop right there and they'll return it. So it's possible that someone will receive this letter back saying, oh, this is what was incomplete. I'll fix this and resubmit it, only for a subsequent officer to say, there is also this that is also incomplete.
Yeah, so the other piece to note about that is once you get this letter, I mean, this letter is the absolute nightmare for any person to receive because, as you say, like it might be that now you've got a refusal. It's not just like you can call them up and say, hey, can I actually just provide that letter? If the category in which you applied has since closed or filled up, or the rules about who qualifies changes, then that's just it. That's the end of the line. You might be able to challenge the decision. We're going to move on to this part in a minute, but let's say you can challenge the decision and you want to take that decision to the federal court. Right now, federal court wait times are clocking in at around 16, 18 months in the Western region. Maybe I'm understating it. They keep going up and up as every week goes by. They're much longer in the central region. But also, as Steve is going to explain, it's not like you're guaranteed that you're going to be able to get them to agree that this was a decision made that is subject to judicial review. I think this is what has been contentious.
Yeah, we will get to, I just wanted to highlight, you raised a very good point, Deanna, about how sometimes it's not just the simple matter of reapplying. In the parent and grandparent program, for example, no new sponsors have been invited to sponsor their parents since 2020. So if you have an application in the parent and grandparent program that since 2020 was rejected for incompleteness, there's not been an opportunity in those 5 years to try to, in that case, even just re-enter the lottery.
Mhm.
The I have one case ongoing right now where a parent and grandparent application was returned for incompleteness that we are seeking judicial review on, where the person basically submitted an application where a 60 or 70-year-old person provided a resume that had a several month gap in employment. And that was the cause of the application being deemed incomplete and returned, which results essentially, if the decision stands, for this person possibly forever not being able to sponsor their parents to immigrate. And it just demonstrates the harshness with which this is applied. And I'm going
Especially
to
if
just,
it's like their resume is not updated, but they had provided a separate form that provided all the same
mhm.
information with their work and address and employment history. All of that was set out in the IRCC forms. It didn't say that there needed to be no gaps on the
Oh, there's cases out there too where people uploaded the wrong version of the form. The form had been changed in the week before they applied and they missed it, or there had been two updates in a short period where in the types where there's no grace period.
Or what
I
about when the
do.
fee has been updated because they do update the fees from time to time? I haven't seen one of those, but I have another case that, anyways, it's different but similar.
Now I'm gonna on a little bit of a tangent or a rant
Okay.
is what kills me about this, and this is one of the things that I've talked about on the podcast before, is I don't like programs that are run in a way that are designed to manipulate stats.
Mm,
And what this is, in my opinion, is just pure stats manipulation
sure.
because the government will say that processing only starts once an application is complete. So
Right.
before this, the department may have gone back and forth with people, and so it would have taken longer to process the application. So people would have complained about long processing times. The result is the government saying, okay, fine, we're only counting processing as once an application is complete. This reduces the amount that officially an application took to process. But let's say that you are that person who I talked about, or who you gave the example of, where there are several months to do an R10 determination. If someone submits an application and 3 months later it's returned, and then they reapply, and 6 months later it's approved, should the processing time for that be 6 months, which is what it officially is, or 9 months, which is the amount of actual time that they are interacting with the department? For the
Clearly
person
not.
interacting with the system, it is, of course, the amount of time that they are actually spending interacting with the system. But for government publications and for people who may not know how this is all tracked better, this rigid R10 process allows the government to say that it has shorter processing times.
Yeah.
Drives me nuts.
I'm gonna jump on that because I got one more like little jab to add to your rant, which is that I think that the purpose, that was the reason why completeness screening began, is because it was a taxation on the government resources that they had to spend all sorts of time reviewing incomplete applications. That was the objective, to like more efficiently use officer resources. This is exactly the opposite of that, because what it means is that they're in this like hunt for any reason. What it's become is really a method for managing inventory. Is that if you get 1,000 applications and you can find any reason to return half of them, oh, that box was not completed properly. I'm going to use that as a reason to send it back to you. Well, then all of a sudden you only have 500 applications to process. Great. And also, we can say that we're keeping up this processing standard and that we don't have a backlog. So they won't have to say that they're sitting on this great big inventory. They're saying that, in fact, they have half of that amount of inventory.
And in terms of the volumes, I pulled up on, for those watching on YouTube, the stat that I obtained through an Access to Information Act, which shows that since Express Entry was launched, about 6.5% of the applications were rejected for incompleteness. That might not seem necessarily like a lot, but that's 40,500 applications that went through this triage and were returned. Depending on when someone may have interacted with the system, it may have permanently cost them the ability to immigrate to Canada. If the points went up after they submitted their application such that they no longer had enough points, or if they just stopped doing draws in certain categories.
So again, like, I mean, if you have a fully defective application where certain components of it that are required to be able to make a determination aren't present, I understand. But where it's a color versus a black and white photocopy, I really have a lot more trouble with it. Or that you haven't explained that New York infers the United States of America.
Yeah, it's
Pretty low hanging fruit.
Oh, it would be interesting actually to see the breakdown of what percent would have actually caused significant delays, or as they often do, those watching can see, of the 630,000 applications that IRCC received in Express Entry since 2015, 161,000 required a request letter. So, of the applications that are completely bounced, how many people would have been able to immigrate had IRCC just sent a request letter instead of returning the application for incompleteness?
Yeah, I also have a little bit of I guess my backup a little bit, applications requiring a request letter, because I do a lot of caregiver files and I often receive 6 different request letters on the same file. One that's like, please do a medical. One that's like, please have your spouse do a medical. The next one that's like, please have your son do a medical, you know? And so the actual need to have so many request letters, I think, is again largely about operational inefficiency. Or sometimes it's like, oh, you provided this form for us 3 months ago. Please send us an updated version. Not that there's any actual substantive update, but so again, I feel like there's a lot of gaming in these stats, and I don't think that we can look to this data as being a full reflection of the reality of what the quality of applications is across the board.
Yep. As far as what the courts have said, the leading federal court of appeal decision that gets cited all the time is a federal court of appeal decision called Gennai, Gennia. For those who want the neutral citation, it is 2017 FCA 29. And the big thing that this case stands for is the proposition and this sentence, which is, I agree with the judge. This was a federal court of appeal decision, so it was a federal court judge, that an incomplete application is not an application within the meaning of the Immigration and Refugee Protection Act and the regulations. In my view, an incomplete application can no longer exist because the text of Section 12 of the application of the regulations provides that the entirety of an application that has failed to meet the requirements under Section 10 is returned to the applicant. Whether this statement that an incomplete application is not an application has led to all sorts of issues in terms of whether whether someone can seek judicial review, which I'll get to in a bit, but also what it means for matters like maintained status. If an application is
Mhm.
not an application because it is returned for incomplete,
Oh,
let's say somebody applies to extend their work permit before it expires. Canadian immigration law provides that that person can work while their application is in process. If the application is bounced for incompleteness and the application then technically never existed, then was all that work unauthorized, such that they worked illegally? It's a bit of a gray zone in the law and just one of the questions and issues that this sentence from this decision has caused.
Yeah. I mean, like, I know that this is the Federal Court of Appeal, but I think this is bad law. And I would say, and I know that I think you've had the same experience, Steve. I have resolved several R9, sorry, R10 bounces where the department seems to have agreed that this was a mistake and the thing was settled. And so, I do think that they're resolvable in certain circumstances. But yeah, um, uh, this is upsetting to
Yeah.
me.
I have two comments too about this decision as far as the politics goes. The first was I read in an ATIP once where it seemed like a minister was asking, why is this so strict? Why is this so strict? And the department was explaining to them in this memo and briefing note, well, in Gennai, the Federal Court of Appeal said that they aren't applications, so it's left us with no choice but to be very strict. And I was reading this memo thinking to myself, you're acting like the decision was just thrust on you. Like it wasn't like your lawyers who were arguing this in court that led to the win and for the government, and now your hands are tied. The
Yeah.
second, and this is something that I had tweeted during COVID that got a lot of feedback from people who follow me on Twitter, was during COVID at the Standing Committee on Citizenship and Immigration. Many MPs started asking, hey, we're hearing about files that are being bounced for incompleteness and that family reunification is being delayed. And is this true? And the minister, as well as the department, both said that applications weren't being returned. So I've attached one quote here that you'll be able to see on YouTube from a department official that where the person said, instead of sending the file back for completion, we can get that information either by contacting the applicant by phone or by other means and then fulfilling those requirements in-house. And there's another quote where the minister said that no applications were being returned for incompleteness. And I raised this with someone who I won't name, and their response was, well, technically that's accurate because there are no applications being returned for incompleteness. It's only an application if it passes R10.
Oh my God.
And again, it was just one of those moments where thought to myself, that's it. I'm not believing anything the government ever tells me anymore.
God.
Like, if that
Like
is
I'm
the
in an
level of
Escher drama.
gamesmanship that we're playing with naming, like, no one is going to know in the public that by an application being returned, it's referring
Yeah.
to applications that have passed R10 because the Federal Court of Appeal in Gennai said that an incomplete application is technically not an application.
Wow. It's funny when you read this first sentence about we've started to look into more client-centric approaches with that backdrop. It feels like you're having a conversation with the Cheshire Cat or something. It's like, what?
Yep.
Yeah, client-centric indeed.
And so Deanna and I have talked about how the current state of the law involving bounces is getting more and more unclear, and I'd say more and more complicated. I don't know which was the first decision, especially for files involving ministerial instructions, but someone, a DOJ litigator, noticed that the Immigration Refugee Protection Act says that in the context of applications submitted under ministerial instructions, like caregivers, express entry to an extent, the parent and grandparent program, a whole bunch of programs, the fact that an application or request is retained, returned, or otherwise disposed of does not constitute a decision not to issue the visa or other document or grant the status or exemption in relation to which the application or request is made. That sentence has since been used in several decisions by the federal court and by the Department of Justice to say that incompleteness bounces cannot be challenged, no matter how unreasonable, whether it's completely actually wrong, there is no recourse and the decisions cannot be challenged. A recent decision, and the one that prompted me to suggest this topic is a case Goel v. Canada Citizenship and Immigration, again, the neutral citation, 2025 FC 275, which involved a bounced express entry application where an applicant had provided a marriage license and not a marriage certificate in their application. And the person contacted IRCC saying, please reconsider this, and they were unsuccessful. And there's a big contested issue within the decision and the applicant saying this is a this should count as a marriage certificate. I don't believe my application was incomplete. On a side note, one of the lawyers at our firm helped someone who, I believe it is the state of Texas, their marriage certificates are called marriage licenses.
Hmm,
And so somebody had a bounce where the department went, oh, you provided a marriage license, not a certificate. And they were successful in that case in explaining, hey, in Texas, the document's just called marriage license.
right.
Here, they refused to reconsider it, so it went to court. And the first issue that the judge had to contend with was, does the judge even have the ability to look at this? And the judge cited numerous cases where the federal court said that they aren't able to look at whether a or aren't able to decide the reasonableness of a decision to return an incomplete application. Here, the judge said that in cases where someone is challenging the very fact of whether or not the application is incomplete at all, as opposed to the reasonableness of a decision to return an application for incompleteness, which is a very fine technical point, that that is justiciable and can be looked at. So the federal court basically said here, very fine-tuned distinguishing that they can look at matters not where people are trying to fix applications, but where they're challenging whether something was even wrong in the first place,
Right.
which, whether or not this will be the final edict or determination on this remains to be seen. I'm one of those people who thinks that in a system that is lacking recourse for mistakes, that the federal court will hopefully, where possible, and in as many instances as it can, kind of provide that overview as to whether decisions are reasonable or not.
For
And
sure.
here they found that the decision was unreasonable,
Yeah,
which again, and I'm sure everyone has seen this, someone can apply, get a decision, seek reconsideration, get the same refusal, and it's only through the federal court process that it seems like matters can actually be reviewed properly. So
totally.
I'm sure
Can
you
we
agree
just
with me that
look?
hopefully these like this becomes sort of the state of things, that the federal court does agree that they can be reviewing these matters.
Me too. Yes, you're correct. Can we just look back and see when this actual decision was made as compared to when the decision was rendered to give everybody a perspective on how long it took?
Oh, I see what you mean.
Yeah,
So I don't know if it has
usually they
a
do.
date
Uh,
for when it
no, it
happened. I
doesn't.
don't
It
think it
doesn't.
does.
We could look at the docket to find out. But anyways, this is my new thing. Oh wait,
Well, it's
was it that one?
IMM 1797 2024. So that would have been, considering the federal court had about 24,000 cases,
It's right at the beginning of
would have been at the beginning
2024.
of 2024 when the judicial review is filed,
I
and the
think at the very
decision is
bottom of the
February 12, 2025.
Yeah, I think it said at the very bottom that the decision was, oh no, that
Oh,
was
dated. Yeah,
the
you're right. The
decision. Yeah.
decision dated January 30, 2024.
So it took them a year and like
A year and a month.
yeah, a year and a month to get now
Well,
that
no,
the
about a year,
decision is
yeah, a year and a
overturned.
month.
This doesn't mean that they now win. It means that now the whole application gets reopened and they have to wait whatever length of time it is for a new decision to be made. Whether or not the new officer makes a different completeness screening decision or finds some different problem with the application is left to be seen. But this is the type of consequence people go through based on what the court found to have been just like, no, 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 you should have actually looked, made a request,
Yep. And the alternative, as slow as that is, would have been no permanent residence application.
perhaps ever.
perhaps ever, because I'm assuming they didn't get re-invited. Otherwise, they presumably would have discontinued the judicial review. So
For
in that
sure.
case, it's realistic to assume that but for that bounce, where again, at the initial application and the reconsideration, IRCC dug in, the federal court saw it differently and said, nope, this people weren't taking their time to slowly look at whether a mistake had been made here.
Yeah, for sure. And with the score continuously climbing because the levels plan was just sort of like hacked away so much at the numbers, that number is not coming down anytime soon. So really, this was the only recourse that these litigants had available to them.
Do you want me to conclude with something depressing sounding that I said to some lawyers at the firm?
Yeah.
And we keep talking about how like this is going to be 2 years at least, 2025 and 2026 in the levels plan are the tough years for people wanting to immigrate.
Mm.
We're less than 10% through that. There, those who can,
People are already like, I can't handle it anymore. How many phone calls are we getting every day?
right?
Like,
We're less than 10% through the what is supposed to be a very strict 2 years, and that's assuming it gets better and it
yeah.
gets that immigration levels go back up. We're going to have some episodes upcoming about the liberal leadership race and depending on the timing of it, the next election. But some of the current platforms coming out from different candidates, I saw Pierre Poilievre wants immigration back to 2015 levels. So the numbers
Oh
and
my
the
God,
tone of
what a
things could be
delay.
getting strict. And one way to keep numbers down is to bounce all the applications so that all ties together.
But this one actually provokes another episode on A16 and A11, which is yet another way that they are
You're going to
rejecting
have to do a
applications.
two-sentence summary to explain what that
So
is for people who don't know the
like
provisions of the act.
bizarre reasons for saying that people have not like a complete application filed, but then they find a way of requesting information that I think is very dubious. I think that there are a lot of the time kind of fishing expedition type questions. And then when the person fails to respond to the standard put forward, they either make an allegation that they failed to answer fully and completely, or that they did not respond essentially in a way that allows their application to be assessed on eligibility and admissibility grounds. So they don't find any specific inadmissibility. They just say, well, we can't make that determination, and so we're going to refuse your application. So it's sort of like an end run around admissibility and eligibility determination, and it's kind of like an after the fact completeness barrier.
Yeah.
And I'm getting an absolute landslide of these types of decisions too. So I've got to be in my bonnet about that.
Yeah, we'll have to do an episode on it. You and I were talking with some other lawyers on Signal, and I think we both agree that there seems to be something up with IRCC's global case management system where documents that people are credibly are saying were submitted don't seem to be being received. But that's a topic for another episode.
Well, not just that, but that the department is saying we sent you a procedural fairness, and the clients will swear under oath they never received that procedural fairness letter, and the department is going to the bank. Yep, we sent it, and then okay, produce a copy. Oh,
Yeah.
can't.
It reminds me just like so we were once waiting for a client's, I think a work permit or a PR card or something. And I called the department to say, hey, where is the work permit? And the agent said, can I confirm your address with you? And I said, yes. And he goes, is it 555555555 West Georgia Street? And I said, there are way too many fives on there. Let's get that down to three and try resending it. And they went, oh, I think someone screwed up when inputting where to mail it to. Oh,
Oh
God.
my God.
Anyway,
Yeah,
good
pretty
talking.
amazing. Yeah, yeah, good talking. Best of luck.
Yeah.
Fortitude. Okay.